Over a decade ago, the question on all online denizens' minds involved the auditory practices of members of the genus Vulpes, a question more commonly expressed as, "What does the fox say?" Our Norwegian compatriots may have been less than accurate on fox noises, as foxes in reality produce sounds reminiscent of horrid eldritch cryptids. But inquiries regarding vulpine characteristics are not confined to the musical sphere. The legal profession has its own query on foxes, although it's more complicated and less catchy. The question is, when does a wild fox, or any wild animal, become the property of a person hunting it? This question was debated and answered in the 1805 Supreme Court of New York case, Pierson v. Post. Pierson v. Post has become a foundational case in the field of property law for the United States. Most lawyers will call it simply the Fox case amongst other lawyers. Law students will read it in their law school's introductory property class, most likely in the student's first year. Property, legally speaking, can be thought of as a variety of things. One view is that property is a right to a thing good against the world. By this, I mean that you have the right to possess the thing or object, and that right will protect other people or entities from making use of it. You have a right to prevent people from living in your house or driving your car because the house or car is your property. Another way to look at it, in a more intellectual sense, is that property is a bundle of rights that contain different rights based on context and policy. A person may possess legal title and have the right to sell or transfer ownership to a plot of land, but the right to obtain minerals underneath the ground may be held by another person, who could have been given the rights by the person with the legal title. As you may have guessed, property law oftentimes goes deeper into philosophical and practical issues than other areas of law. Some may like that, some may hate it. As we continue, we'll see that the opinion in Pierson v. Post delves into economic and philosophical debates on property and the essence of what property is. Ownership of property can be established by simply being the first person to possess something that is unclaimed, like a wild animal. Pierson v. Post determines that a person must capture and possess a wild animal to acquire ownership of the animal, not to just be pursuing it. We'll also see that the real dispute may not have been about the fox at all, but about differing opinions on how public land should be organized and controlled. Our dispute involves two men arguing over who had ownership of a fox that both were hunting. We are on Long Island in the very, very early days of American independence. It is December 10th, 1802, and the Constitution is only 13 years old. The opinion states the events took place, quote, upon a certain wild and uninhabited, unpossessed, and waste land called the Beach. Today, we know this area as the town of Southampton, New York. Southampton, part of the Hamptons, is today home to some of the wealthiest communities in the country. Peter's Pond, where the events are said to have occurred, is located in the village of Sagaponack. Sagaponack was once the most expensive zip code in the United States, with a 2016 median home price of $8.5 million. Ira Rennert's 66,000 square foot Fairfield compound is adjacent to the Peter's Pond where the events of the case took place. How things change. Anyways, back in 1802, Mr. Lodowick Post is out fox hunting with his horses and hounds. He and his dogs find a fox and start to pursue it across the land. Jesse Pierson, a school teacher walking home from work, sees the fox run into an old well near the pond. Taking a broken fence post, Pierson kills and carries off the fox. Allegedly, when Mr. Post confronts Mr. Pierson about taking the fox, Mr. Pierson states that, "It may be you was going to kill him, but you did not kill him. I was going to kill him, and did kill him." He has such a way with words. What happens after this is a bit muddled, since this case is over 2 centuries old, and the court at the time did not have the luxury of modern recording systems. The record, recently discovered by Professor Angela Fernandez of the University of Toronto, misses lots of what's included in modern-day case records, like witness testimony and written pleadings. What we do know is that the case was heard by John N. Fordham, a justice of the peace in Suffolk County, not Queens County, which the published opinion erroneously states. Mr. Post claimed that Pierson's conduct interfered with the hunt and injured him in the amount of $25 in 1802 dollars. Notice how the claim of being injured by interfering with the hunt is more reminiscent of a tort law claim, like conversion, rather than a question of property law. The specific claim was trespass on the case, which was a catch-all when no other claim matched the plaintiff's injuries. Professor Fernandez concludes that what happened was that the jury simply gave Post a remedy without worrying about what category of law was relevant. The whole question of who owned the fox at the time might have been the judges deciding the case, trying to fit the case's legal claims into the common law at the time. If you investigate and read more of these antediluvian pre-20th century cases, there's much less emphasis on formalities. In fact, this whole first stage of the trial was probably held in a private home, without any lawyers present. For some reason, Post considered this case serious enough for a jury to decide. After less than a month of trial, if only we could go back to that, the jury found for Mr. Post and awarded him the princely sum of 75 cents for damages. The market value at the time for a fox pelt was around $1, so it's not an unreasonable award. The jury also held that Mr. Pierson should pay for the costs of the trial, which amounted to around $5. Pierson appealed the case to the Supreme Court of Judicature of New York, now called the New York Supreme Court, which is not the Supreme Court of New York. It's a bit complicated. Basically, the New York Supreme Court is in reality the trial court for the state of New York. This means that it's on the first level of the New York courts. There are other courts which are on the same level, including a full separate court for New York City, but the Supreme Court hears civil cases above a certain monetary amount. The actual Supreme Court for New York is the less impressively named Court of Appeals of New York. Why this is, I have no idea. Maybe the court was considered supreme over these podunk justices of the peace. Pierson's lawyer overseeing the appeal, Nathan Sanford, is a big hitter in New York during this time. Born to uneducated parents, he went on to attend Yale University with the encouragement of the Pierson family. In 1802, the year of this case, he was the newly appointed U.S. Commissioner of Bankruptcy and would later be appointed U.S. District Attorney for New York in 1803. His strategy is to allege that multiple errors were committed by Justice Fordham. 6 of these errors are listed, but all of them were abandoned except for one. The error taken up by the New York Supreme Court is that Post's claim was not, quote, sufficient in law to maintain an action. Essentially, this means that even if everything alleged by Post was true, namely that Pierson intentionally interfered with Post's hunt, it was not enough to sustain a legal claim against Pierson. For any law students out there, this sounds like the motion to dismiss standard for failure to state a claim under Federal Rule 12b-6, the bane of any civil procedure student. Under what legal basis the facts at issue here do not support a claim is unclear. Professor Fernandez points to a possible tort law or property law point, but it honestly does not matter for our purposes. We have a star-studded judicial bench hearing this case as well. Justice Daniel Tompkins, the opinion writer, will be elected the governor of New York a mere 2 years after this case. He will eventually become Vice President of the United States under President James Monroe. Justice Henry Livingston, who will write the dissent, will later become a Justice of the United States Supreme Court in 1807. Chief Justice James Kent was the first professor of law at what is now Columbia University and was extremely influential in American jurisprudence. Quite an intimidating bench to argue in front of, I'm sure. Both Pierson and Post's lawyers seem to be up for the task, however. We have already discussed Nathan Sanford, Mr. Pierson's lawyer, but Lodowick Post also allegedly has a highfalutin city lawyer. Recorded only under the surname Colden, he may have been David Cadwallader Colden, who was appointed the U.S. District Attorney in 1798 and would later serve as the mayor of New York City, a position for only the most esteemed and respected politicians, as we all know. The case report helpfully includes what the lawyers said at argument on appeal, although I am unsure whether this is a summary or a transcript of what they said. The question both sides sought to answer, helpfully summarized by Justice Tompkins, is how someone can acquire property rights to a wild animal, described as fere naturae here. Both sides agree that wild animals inherently belong to no one and that a person must occupy a wild animal to gain it as property. Sanford, obviously putting his classical education to good use, quotes lengthily in Latin from Justinian to support his argument that occupancy only occurs when someone captures and seizes the animal. On the other hand, Colden argues that occupancy does not have to involve capturing the animal, but that a person who first pursues a wild animal gains an exclusive right while following the animal. He relies on legal theorist Pufendorf and Barbarack, a commentator on Pufendorf. All you need to know for our purposes is that these are influential scholars at the time. If the Supreme Court of New York prefers Colden's argument, then Mr. Pierson would be liable for damaging and taking Mr. Post's property because the fox was Mr. Post's property at the time. If the court prefers Sanford's argument, then Post cannot win on a claim because the fox was not his property. Let's introduce an analogy to explain the argument, shall we? There's a quarter on the ground. Two people, Calvin and Susie, are both walking towards the quarter from opposite directions. Calvin sees the quarter first, points at it, and shouts out, "Dibs on the quarter!" Susie then sees it, but runs faster and puts the quarter in her pocket. Sanford's argument is that the quarter is Susie's property because she put it in her physical possession first. Colden's argument is that the quarter is Calvin's property because he saw it first and gained the right to it while he made his way to the quarter. Two sides of the argument, both with their positives and negatives, pros and cons, but one side ends up victorious and remains good law in the United States. Sometime in August or September 1805, the court delivers its opinion, written by Justice Tompkins and joined by Justice Kent, with a dissent authored by Justice Livingston. The court holds in favor of Mr. Pierson, finding that, quote, mere pursuit gave Post no legal right to the fox, but that he became the property of Pierson, who intercepted and killed him. In other words, whoever first captured the wild animal possesses and has property rights over the animal. The court's decision is based on references to several ancient precedents from legal scholars, including all the previously mentioned names. However, the court does not simply rely unquestioningly on these sources, but also approves the policy they articulate. Justice Tompkins reasons that a more substantial basis for claiming possession is needed rather than just pursuing a wild animal, stating that, quote, if the first seeing, starting, or pursuing such animals, without having so wounded, circumvented, or ensnared them, so as to deprive them of their natural liberty and subject them to the control of their pursuer, should afford the basis of actions against others for intercepting and killing them, it would prove a fertile source of quarrels and litigation. This is a twofer of common reasons for certain legal decisions, the good old slippery slope argument, and the court's worry that they might have to do more work. If there is anything judges love more than doing their jobs, it's not doing their jobs. Livingston's dissent, on the other hand, finds that the fox was Mr. Post's property. In his opinion, a person who pursues a wild animal and has a reasonable prospect of taking control of the animal acquires the animal as his property. Justice Livingston also takes the now in vogue position that the decision should not be based on scholarly authority at all, writing that the whole dispute should have been submitted to the arbitration of sportsmen without poring over Justinian, Fleta, Bracton, Pufendorf, Locke, Barbarack, or Blackstone. They would have had no difficulty in coming to a prompt and correct conclusion. Assumedly, the hunters would have considered Mr. Post to have first possession of the fox because he was in pursuit of it. Livingston also discusses policy considerations. At the time, foxes were considered a wild and noxious beast that preyed on farm animals, and to put foxes to death wherever found is allowed to be meritorious and of public benefit. In fact, Southampton agreed to pay 4 shillings for every fox killed between March 20th and June 20th of 1791. To Livingston, awarding possession of a fox to the pursuer incentivizes hunters to pursue the societally beneficial action of hunting vermin like foxes. In probably the most famous phrase from the case, Justice Livingston characterizes Mr. Pierson as a saucy intruder and theorizes that hunters would not put in the investment to hunt if the aforementioned saucy intruder, quote, who had not shared in the honors or labors of the chase, were permitted to come in at the death and bear away in triumph the object of pursuit. What's interesting about the decision and the dissent is what they both are missing. Neither mention Blackstone's Commentaries on the Law, a legal treatise that is extremely influential in common law. Even today, the Supreme Court cites Blackstone when discussing historical jurisprudence. Blackstone's treatise would have been what most of the lawyers and judges involved here would have been trained on. So why no mention of Blackstone? Professor Bethany Berger of the University of Iowa College of Law suggests that this was due to American judges wanting to reject the authority of English law and instead looking to the universal principles of Roman law and Enlightenment-era philosophers. This makes sense considering the time period. America had just been at war with Great Britain a little less than 20 years previously. If you've broken off ties with your parents, you're hardly keen to still follow their rules. Instead, the court started to tie American law to universal principles and ancient sources like the Romans, much like how the Founding Fathers based their new government on the democracies of Rome and Greece. In any case, congratulations, Mr. Pierson. The fox is officially yours. Since it's been 2 years, it might be a little bonier and smellier than you wanted, but I'm sure you're proud of the moral victory. You also might be happy about not having to pay the equivalent of $174 in today's money for stealing someone else's property. In fact, Mr. Post ended up having to pay Mr. Pierson $121.37, the equivalent of $3,260.90 in 2025, for costs and charges incurred because of the trial. It is quite interesting that this much time, effort, and resources were exerted into the 19th century equivalent of Jamie Lee Curtis fighting over the hickory honey ham in Christmas with the Cranks.
Happy holidays.
Top lawyers, grandiose sources, and a deeply divided court. Is it really that serious? Professor Fernandez, in her 2009 Law and History Review article on Pierson v. Post, sets forth a compelling explanation of the style of the opinion and dissent and why the judges may have written the way they did. Her theory is that the entire opinion was a sort of exercise in judicial reasoning, a moot court debate. Possibly it was even a teaching exercise given by Chief Justice Kent. Justice Tompkins, who wrote the opinion, was a former student of Justice Kent. The court might have seen the dispute as a vehicle to flesh out a new legal course for property law and use the opinion and dissent to map out the legal debate. Perhaps the justices thought that the opinion would be used to teach law students, as it has been used for over 2 centuries. But what about the parties themselves, Mr. Pierson and Mr. Post? Why did they fight so hard on this case? Professor Berger, in a 2006 article for the Duke Law Journal, sees it as a conflict over the right to use common resources in the town of Southampton and the different social milieux of the two parties. When the town of Southampton was first settled, there were multiple different claims to the land, from different Native American tribes to the Dutch to different British entities. These were eventually settled, but property rights remained deeply important for the residents, reflecting political and economic consequences. In addition, the residents of the town made numerous property agreements that reflected a continuum of shared property rights. The original residents agreed to share property amongst themselves. These holders of the common property, known as the proprietors, had special rights to the common lands that other residents could not, such as the right to take timber from the common land and to have any farm animal graze there. However, between 1663 and 1782, this common land was divided amongst the proprietors and gradually sold off to new migrants in Southampton. Eventually, residents of Southampton who did not have rights to the common land outnumbered the residents who did. After the Revolutionary War, economic and political turmoil engulfed the town. New residents, including those who found economic success, began to assert rights in the common lands that proprietors had long claimed for their own. The Piersons and the Posts found themselves on opposing sides of this situation. The Piersons were a farming family, descendants of one of the original settlers of Southampton and proprietors with special rights in the common land. Peter's Pond, where the fox was caught, lay in some of the common land that multiple members of the Pierson family lived near, and the land was used by the Piersons to pasture their stock. The Piersons were allegedly very protective over their rights in the common land, which was a source of increasing conflict as residents without common land rights challenged the inherited common land rights of the proprietors. Meanwhile, The Posts obtained wealth from commerce and shipping after the Revolutionary War. They allegedly maintained an opulent house and had conspicuous displays of wealth, a stark contrast to the thrifty and poor farmers in the surrounding area. Mr. Post's fox hunting recalled the traditions of the English aristocracy, and the tradition of using common land for recreation instead of sustenance, which might not have gone over well with the Piersons. Mr. Pierson, seeing Mr. Post trample the common land he had special rights to with horses and hounds, might have been upset in the same way as English peasants were upset at English lords who trespassed on common land while hunting. Mr. Post, however, may have been upset at Mr. Pierson being a saucy intruder and ruining his hunt, especially on common land where the Piersons asserted that residents like the Post did not have equal rights to use said common land. Although the fight was ostensibly about a fox, the fight might have really been about the status, land rights, and the distribution of resources in the town of Southampton. It's an intriguing theory, but it's only a theory. We can't exactly speak to Mr. Post or Mr. Pierson and delve into their mental state at the time of the dispute. Whatever might have been the intentions of the parties or the historical and sociological background of the final opinion, Pierson v. Post has ended up being an essential case to teach law students about property. I hope that you come out of this video with a basic understanding of the concept of property and how property is created. Until next time, I'm Lex Ursa. Have a nice day.